House Elections, Constitutional Amendments, and Intergovernmental Affairs Committee is called to order. Madam Secretary, please call the roll.
Representative Baker. Here. Representative Bivens. Representative Branscombe.
Here.
Representative Callaway.
Here.
Representative Chester Burton. Representative Decker.
Present.
Representative Gooch.
Here.
Representative Hancock.
Here.
Representative Imes.
Here.
Representative Cook.
Here.
Representative Lewis. Here. Representative Lockett.
Here.
Representative Marzian. Representative Roberts.
Here.
Representative Hodgson.
Here.
Representative Johnson.
Present. And we do have a quorum. We can do business. I'd like to kick the meeting off, as always, with a pledge allegiance and a prayer. And I've asked Representative Imes to open us in prayer after we do the pledge. So if you would stand and join me. Thank you, Representative Imes. A couple of quick administrative announcements. Please remember that when you are speaking, be sure that you turn the microphone on. You have that green button, very, very green. Please make sure that you've silenced or turned off your cell phones. And we will be implementing the 24-hour rule for committee amendments and committee substitutes to the extent possible. I think last night we made it in as far as the previous day, but even though it wasn't 24 hours, I appreciate your understanding there. And we will be swearing in all of our speakers today. Do any members have any special guests they would like to introduce to us today? Seeing none, we have two bills on the agenda for consideration today. The first item on the agenda is House Bill 684, local mandate, and sponsored by Representative Jennifer Deckard. Representative Decker, would you please come forward? Would you please each raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Very well. You are sworn in. If you would, please, each of you introduce yourselves, and then I understand we have a committee substitute. We'll take care of that.
I'm Jennifer Decker, State Representative from District 58.
I'm Candy Massaroni, State Representative from District 50.
I'm Jason Denny, past president of Kentucky County Clerks Association, Anderson County Clerk.
Thank you. Do we have a motion to adopt the proposed committee substitute?
Motion.
We had a motion, second?
Second.
All in favor? Aye. All opposed? Motion passes. We are now considering the committee substitute for House Bill 684. Representative Decker, the floor is yours.
Thank you, Mr. Chairman, and thank you to the committee members. Thank you, Mr. Chairman, and to each of you committee members. It's an honor to serve on this committee. When I ran for state representative, I pledged to continue and work the whole time I was in office to work on the elections to ensure they were fair and free in our state. Every year that I have served, I've introduced a bill just for that purpose. The focus has been to improve the integrity of our elections and to increase voter turnout. 2 years ago, former Secretary of State Trey Grayson named the types of bills that I introduced as continuous improvement bills, and that kind of sums it up. During each interim session, and especially after each general election, I meet with a very informal but serious work group made up of representatives from the State Board of Elections, the Secretary of State's office, the various individual clerks, county clerks, the County Clerks Association, various state legislators who focus on the elections area, and various concerned citizens who have a great deal of input. We start planning as soon as the elections are over for the next continuous improvement bill. And House Bill 684 is the result of that type of collaboration. I'd be happy now to walk this committee through each section of the bill and to let you know what it does.
I think it's important that you do so,
Yes.
but time constraints are always being
Yes.
what they are. If you could just briefly hit the highlights. Thank you.
And I want to thank Shannon Tubbs for all her work on the bill and for her excellent advice and help in it. So in Section 1, it allows a lesser number of precinct officers if a county has decided to combine some precincts in vote centers. It's hard to get precinct officers. Sometimes that's why precincts are combined. And so we recognize that there won't be as many needed if that happens. Doesn't have to happen in any county, but if it does. Section 2 requires the County Board of Elections to notify local boards of education if there is an intent to use a school for a voting center. It also requires that the clerk specify which building will be used and the dates and times they will be used. This will happen each December prior to the election, so the schools have time to plan. Section 3 allows a county board of elections to request an amendment to its previously submitted precinct consolidation plan if it is done 56 days before a special election. Section 4 allows caregivers. This was brought to us from various constituents that if you are a caretaker and of a qualified person who has an excused in-person absentee ballot, they go into the clerk's office, they are helping a voter, those caregivers are allowed to vote on that same day. Section 5 allows the county clerk to issue voters a mail-in absentee ballot if they come in and tell us they haven't received it. We all know problems with the mail. Their previously issued absentee ballot is canceled and a new one is issued. Section 6 allows the county clerk to dispose of video surveillance of the drop boxes 60 days after an election, or if it complies with the Kentucky Open Records Act and or the closure of an investigation, litigation, including appeals. So we want to ensure that that surveillance is kept a reasonable time to allow all of that to occur. Section 8 removes the requirement that the County Board of Elections make the determination of whether a voter requires permanent voting assistance. They're not qualified to do that. So we replace that with a certification subject to the penalties of perjury if someone is permanently needing assistance. Section 9 changes the deadline to file to run as a write-in candidate to the same deadline as the certification of candidates so that people don't decide to write in after that certification date. It prohibits certified lists of write-in candidates from being posted. In my county, there was a write-in election, and they actually put the list of names in each voting booth. So this will stop any posting, could be seen as electioneering, of names in write-in. It allows the voters to review a copy of all the write-in candidates and then give it back, but it is not allowed to be posted anywhere. Section 10 removes language regarding voting equipment that's no longer used in Kentucky. That old language talked about voting machines that don't print out the name of the candidate with their votes. We don't have those anymore, so that's stricken. Section 11 allows the county clerk to dispose of the video surveillance of voting equipment after 60 days upon the completion or as required by the Kentucky Open Records Act. This will be the deadline but after the closure of any investigation, same language, litigation, including appeals. And that's already in the law, but what had to happen was we had to add the litigation, including appeals, just to ensure that, that those records were kept. Section 12 is just conforming language. Section 13 allows video surveillance of the hand-to-eye audits to be disposed of the same amount of time, 60 days, with the same requirements of that 60 days or after litigation, etc. Section 14 requires that two voters signing a candidate's notification and declaration are of the same party and from the same district or jurisdiction as the candidate at the time of signings. We had litigation this summer when it was learned that that the witnesses did not have the same party, but they changed their party to be the same, and then there had to be litigation about what the statute actually meant about the time, and so we've now stated that it's clearly at the time of signing. One of the things in the committee sub that's now been adopted is that we are now requiring that the declaration and notification of the candidate's filing will include the candidate's date of birth. This was necessary because there are often times when people have the same name and it's not clear in the jurisdiction which of the two are running. So we added that to the application to run, which will not be posted on the internet. There's clarification in section 15 about when candidates shall file nomination papers. Just the dates are set forth clear. Section 16 requires that a candidate's district number be listed with the Secretary of State rather than his or her residence. This is a matter of safety. I will tell you that I learned recently in working on this that a few years ago someone posted on Twitter my home address and encouraged people to come jump the fence. So it is a matter of safety that our personal home addresses are not on the internet. Our district has to be. And by the way, our home address is on the papers that are filed with the Secretary of State. They just don't get posted on the internet. Section 17 is also conforming language. Section 18 requires that a candidate's office and district number be provided to the county clerks rather than his or her residence. Section 19 clarifies that a petitioner for the nomination of a candidate can sign more than one nomination for the same office, form for the same office. So it just allows more people to be nominated to get a bigger slate of candidates to vote for. Section 20 requires the county clerk and Secretary of State to display a candidate's office and district number rather than his residence on the website. Clarifies political affiliation shall only be listed online for partisan candidates.
We have a motion. We have a second. But please continue. Go ahead and finish your summation, please.
Section 21 establishes the deadline for certification of the total number of votes to the Secretary of State following a hand-to-eye count. Section 22 requires the Secretary of State to record a candidate's office and district number rather than his residence to conform with the other changes. Section 23 clarifies that any person who's been convicted of a felony, it's already the law, if they knowingly attempt to vote, it shall be a Class D felony. The change is simply to state that more clearly. Because in the past it was said something about if they were lawfully registered, that was confusing to some people. So we just struck that and said, if you have been convicted of a felony, you cannot vote, and it will be a felony. Section 24 establishes that school districts are not required to close the entire district when buildings are used at voting places. That became a problem during the last election. Those are the various sections of the bill.
Representative Massaroni, do you have anything to add? Did we cover everything?
No, thank you.
I did not mention that change.
Okay.
Go ahead, please.
The committee sub, there was one section that we added. It was to remove the credit card and debit card as a voter ID portion to allow that, not to allow that as a voter ID. It's simply because we do not want financial institutions to determine somebody's residence, and it's open for fraud. So,
Very good.
Thank
Thank you
you.
for that summary. Is there any comments, questions, or discussion? Representative Lewis?
Just have one question on the school piece there. So in the bill, it says the district does not have to close the whole district. What about that particular school?
That is left up to the district as
Okay.
to whether they open or close.
All right, thank you.
Thank you.
Anyone else? Yeah. Representative Roberts?
I do have a question on the school issue as well. What would the mechanics of that look like in the event that a school district does close that specific school? I'm just trying to figure out if there's a certain number of hours that every school has to accomplish, whether, like, how that would work, if that could require schools to be done later, or if that would be utilized as a similar to a snow day. Just wanted to get your take on that.
We don't require any provisions about that. We did not add. That will be up to the school district. Thank you.
Okay, thank you.
Representative Hancock?
Thank you, Mr. Chairman. I just want to clarify for some folks that have reached out to me about the credit card being seen as a voter suppression. I 100% want everybody to know that it is a very small percentage of people that actually use this. It actually slows down the process. So I think we all need to be in agreement. This is not a voter suppression. This is actually just doing what's right and making sure that our elections have integrity. It's a very small portion. So I just had some people reach out to me on that, and I just wanted to clarify that on record. Thank you all.
Thank you. Representative Hodgson?
Yes, Representative Decker, I just want to commend you and your group for the collaborative process that you've gone through over a long time. It's great to get everybody that has a stake in this issue at the table, work these things out, and come up with such a detailed list of positive improvements. And I hope we can continue to do this every year.
Thank you, and we appreciate your participation in that work group.
Anyone else? I do have a quick question myself. It was in either section 5 or 6 with respect to the mail-in ballots and doing it. I forgot what the term you used, but an alternative in case since the first one didn't get received. Is there a process at the voting location to make sure that both those ballots don't get used?
There is, and it's existing in statute, and I will allow Jason Denny, if he wants to add anything to that, tell him how that works.
Right, so if a voter calls, they didn't receive their ballot, they want to be issued a new one. We would the VRS system at State Board of Elections, and it would put a cancellation date on that first ballot, and then it would show a reissue date and the date we mailed out, or as this bill would allow, hand the voter their second ballot in person, and it would cancel that first ballot. The voter would only be allowed to send one ballot back. There was no way that a second ballot could be counted.
Okay, very good. I just want to make sure that we knew that there was a process in place to avoid that. Any other questions or comments? Seeing none, Madam Secretary, please call the roll.
Representative Baker? Yes. Representative Bivens? Yes. Representative Branscombe? Yes. Representative Callaway?
Yes.
Representative Chester Burton? Representative Decker?
Yes.
Representative Gooch?
Yes.
Representative Hancock?
Yes.
Representative Hodgson? Representative Imes?
Yes.
Representative Cook?
Yes.
Representative Lewis? Yes. Representative Lockett?
Yes.
Representative Marzian? Representative Roberts?
Aye.
Representative Johnson?
Yes. And House Bill 684, as amended by the committee substitute, does pass with favorable expression.
Thank you, Mr. Chairman.
Thank you. This time I will turn the meeting over to Vice Chair Hodgson, and we'll move down to the front.
Okay, the second item on our agenda today is House Bill 699, sponsored by Representative D.J. Johnson. It's an act relating to elections. Representative, if you would stand and repeat the oath. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please introduce yourself for the record. You may proceed.
Thank you, Mr. Chairman. State Representative D.J. Johnson representing the 13th District. Mr. Chairman, committee members, I'm here today to present House Bill 699, which addresses some issues with the verification process of filing documents for political candidates of local and state elections. So we have some current challenges in the candidate filing process that this will address. As probably everyone in this committee knows, under current law, candidates for state office file their paperwork with the Secretary of State, while candidates for local office file with their respective county clerk. As a standard practice, filing authorities accept candidate filings as submitted without immediate verification of key eligibility requirements. Among these requirements, candidates must provide their residential address, and for partisan elections, they must indicate their political party affiliation. Despite the simplicity of these requirements, each election cycle, we see it every election cycle, there are some candidates who file and either are ineligible due to where they're living at, is in the wrong jurisdiction, or occasionally we will have someone file for a political party for which they're not registered with. And these errors actually show up virtually every election. Currently, the only mechanism to remove ineligible candidates from the ballot is through a legal challenge in circuit court, which must be filed by a qualified voter or another candidate. This process is often cost prohibitive due to filing fees and legal expenses, and it actually deters the legal process. House Bill 699 introduces a proactive verification process to ensure that candidates meet basic eligibility requirements before their names appear on the ballot. Specifically, it will mandate that by the first Friday following the candidate's filing deadline, the State Board of Elections or the respective County Board of Elections must verify that the candidate's listed residential address is actually within the jurisdiction of the office sought, and that in partisan races, the candidate is registered with the party they are actually seeking the nomination for. If a candidate is deemed ineligible under these criteria, they will not be certified to appear on the ballot. However, there is an appeals process where the candidate can appeal if they think that the decision by the clerk's office or the board has been made in error, and that would go through the circuit court. Mr. Chairman, subject to any questions, I request passage or adoption of
Thank
House
you.
Bill 699.
Any question? All right. Seeing no questions, having a motion and the second on the bill, Madam Secretary, please call the roll.
Representative Baker?
Yes.
Representative Bivens?
Yes.
Representative Branscombe?
Yes.
Representative Callaway?
Yes.
Representative Chester Burton? Representative Decker?
Yes.
Representative Gooch? Representative Hancock?
I would like to explain my vote. I think that the paperwork is very self-explanatory. And if somebody can't fill out the paperwork correctly, I think we probably need to question their, as a litmus test, if they should be running for office. So putting an unnecessary burden administratively on a hard job already, I'm going to go no today, but I'm open for further conversation. Thank you.
Representative Hodgson?
Aye.
Representative Imes?
Yes.
Representative Cook?
Yes.
Representative Lewis?
Yes.
Representative Lockett?
Aye.
Representative Marzian? Representative Roberts?
Aye.
Representative Johnson?
Aye.
All right. The bill passes with favorable expression.
Thank you, Mr. Chairman.
Our last order of business is adjournment. Do I have a motion? Motion. Second. All right. Without objection, so ordered, we are adjourned.